Okay. The meeting is now called to order.
Mr. Chairman, I move that we dispense with the calling of the roll.
Jerry, any second? I sec. Jerry, any second?
I second the motion.
Mr. Chairman, I also move that we dispense with the reading of the minutes and move for its approval.
Any second from our colleagues, members?
Uh, Good afternoon to all of the members, and I second. Okay.
Yeah. So the motion is granted. Let's now proceed with acknowledgement of our guest. Let me start with Deputy Director General Ricardo C. Quinto. Good afternoon, sir. We'd also like to commend you for being early this afternoon to share your insights on the proposed bill. With us also is Deputy Director General for Plans and Operations, Dr. Maharani Tosok, and the Chief of the Legal Affairs and Assistance Division of PIDEA, Attorney Francis S. Del Valle. I'd like to apologize also for the state of my voice because of the continuing interviews about the postponement and holdover situation of our barangay officials. It has become hoarse. Anyway, we'd also like to acknowledge from the Commission on Elections, Attorney Albert Rodriguez and Attorney Renel Tatlonghari.
Good afternoon, Your Honors.
And then from our partners in the NGOs, our ever reliable and our always with the Committee on Suffrage and Electoral Reforms, the Chairman of the Consortium on Electoral Reforms, Mr. Ramon Casible.
Good afternoon po.
The Secretary General of NAMFREL, Mr. Eric Alvia. With him also is a council member of NAMFREL, Mr. Lito Aviria. And of course, the distinguished representative from the 1st District of La Union, Congressman Pablo Ortega. Good afternoon. Okay. We also invited other stakeholders and whose opinion would matter on the pending legislation. They confirmed, but unfortunately they aren't here yet. So, nevertheless, we will now proceed with the agenda on hand. That will be item letter A, the initial deliberation on mandatory drug testing for all candidates. May we acknowledge the sponsor of House Bill number 5680, Congresswoman Geraldine B. Roman, for her sponsorship speech and as well as the explanatory note of the bill. Congresswoman Roman.
Thank you very much, Mr. Chairman. Magandang hapon po sa lahat ng mga resource people, sa ating mga guests ngayong hapon na ito at sa mga isa pa pong miyembro ng Committee on Suffrage. Ang layunin po, the goal of this House Bill is basically, at first I thought of it when I read reports on television that precisely the president was considering canceling the barangay elections on the basis of reports that almost 30% of the barangay officials are involved in the drug trade. So I thought to myself, instead of canceling the elections and resorting to the appointment of barangay officials, which in my honest opinion goes against the essence of our democracy, why not address the very valid and legitimate concern of our president, which is to make sure that all those who aspire to serve in the barangays of our country are not involved at all in the drug trade, nor are drug users. I suppose and I presume that once criminal record is also taken into account when one wants to aspire for a public position. And to my knowledge, the consumption of drugs as well as one's involvement in the drug trade is something criminal. So I thought that a mandatory drug testing as well as a PDEA clearance would be the only solution to find out once and for all if a candidate is qualified or not. Under the present law, it is not included, this kind of testing. And I've also read and have been informed that the Supreme Court has a ruling deeming these additional requirements as something unconstitutional. Well, I am not a lawyer myself, and definitely I am not one to question the ruling of the Supreme Court. But in my humble opinion, you know, if we require drug testing or a PDEA clearance in private corporations or in any sphere in society for that matter, then if it is unconstitutional for elected officials, it should also be unconstitutional at all levels in society. You see, it does not make sense. For me, if as a public official myself, I would not have the moral authority to serve the people if I am involved in criminal activities. And the only way to prove that I am not involved in any criminal activity is precisely through these tests. So I would like to ask the committee as well as the resource people if it is at all feasible given the fact that there is already a ruling in the Supreme Court. Or is there a way by which we could formulate such testing to ensure that all aspirants are not involved in this criminal activity and therefore are qualified to serve the people? Mr. Chairman.
Thank you very much, our sponsor, Congresswoman Roman. The current bill on hand has become more relevant by reason of the current thrust of President Duterte's administration, which is the war on drugs. If I may just ask Deputy Director General Ricardo Quinto, as well as to your team, can you please enlighten this committee? When was the ruling of the Supreme Court that declared unconstitutional a law that requires members of those aspiring to be members of Congress and Senate to undergo mandatory drug testing as unconstitutional? Can you please enlighten this committee? What date was that?
Attorney Francis Del Valle from the Philippine Drug Enforcement Agency. This is relative to the case of Social Justice Society versus Dangerous Drugs Board et al. And this decision of the Supreme Court was issued last November 3, 2008, wherein the Supreme Court declared this similar provision as unconstitutional because according to the Supreme Court, this is an additional requirement to those stated in the Constitution, which is Section 3, Article 6 of the Philippine Constitution, which provides 5 requirements for the candidate for senator or for a public office.
So, according to our Constitution, the only requirements are you must be a citizen of the Philippines, able to read and write, a certain age. What else?
The 5 requirements, number 1 is citizenship requirement, voter registration, literacy, age, and the residency. That is in this case, sir, in the Social Justice Society versus Dangerous Drugs Board.
Well,
Thank you very much.
you will notice that the reason why why the chair asked for that date is because it has become more relevant because never in our history that administration's main focus is the war on drugs. So after almost 10 years since the Supreme Court has decided this case, and it has come out in the open that indeed the entire country situation is we are in a deep drug problem. So the current bill of Congresswoman Roman is timely because as right now we may not have a lot of members right now as they are in other committee hearings, most especially in the Appropriations Committee. They are more interested in the Appropriations Committee. But we understand that this will be a continuing hearing on this particular measure because the prevailing circumstances and the knowledge of the the Supreme Court way back 2008 is now far different at the current time because the current data which the PDEA has showed them has opened their eyes on the drug problem, and they might now consider imposing a mandatory drug testing requirement on candidates. And the chair would like to dissect. Right now, I am currently reading our local government code, and under the local government code, I would like to dissect between those officials which are stated in the Constitution as well as in the local government code. In the Constitution, it's categorically stated in the Supreme Court case that you cannot impose an additional requirement. But here in the local government code, since the local government code is merely a creation of law, nothing prevents Congress from adding a mandatory drug testing on those who would be participating in the local elections, starting from the governor, that includes also local officials, mayor, and if I may ask the sponsor, do you contemplate also of the barangay officials here?
Mr. Chairman, the idea is to cover all elected officials, from the president up to the barangay level. I think it would be more democratic, I would say, and more consistent with the essence and the wisdom of this bill, which is precisely to ensure that no drug addict or drug dealer will actually be able to get an elected position.
Before I ask for the opinion of the Commission on Elections as well as from NAMFREL and Mr. Ramon Casiple, may we recognize first our distinguished colleagues who are present here. From Party List 1 Care, Congressman Caloy Uybarreta. And from the 2nd District of Quezon City, Congressman Winnie Castelo. Thank you, Congressman. So may we hear now from COMELEC what is their opinion on
Mr. Chair.
Yes, Congressman Uybarreta.
I just can't recall the particular Supreme Court decision, but there's already a jurisprudence that since the qualification for president and vice president has been incorporated in the Constitution, any additional requirement that we will impose on them, I'm talking about the president as well as the vice president, would require an amendment of the Constitution. So, Madam Author, if we will include the president as well as the vice president, then we might be this particular bill, if passed, might be susceptible to constitutionality challenge. I'm not just so sure, but I'm sure that there is an existing and prevailing jurisprudence to the effect that any additional requirement other than those stated in the Constitution for Vice President as well as President would require a constitutional amendment.
Mr. Chair, may I answer? Representative Uybarreta is correct. We were talking about this Supreme Court ruling, which is dated 2008. But as our chairman pointed out, maybe in the almost 10 years that have lapsed since that ruling, and given the present situation and the urgency that warrants a measure like this, maybe the members of the Supreme Court would reconsider. Maybe if the course of action, in my understanding, is that once this bill is filed and it pushes through, and then somebody actually challenges its constitutionality, there may be a different ruling. Is that possible?
Yes, thank you. Before we ask for the legal opinion of the COMELEC, we would like to recognize first Congressman Edwin Ong from the 2nd District of Northern Samar. And may we ask the opinion of Deputy Director General Quinto on the matter at hand? In relation, DDG, to the operational aspect, because you have the data as far as the LGUs are concerned, barangays, the municipality. So let's harmonize the data that you have, the intelligence and the intel information that you have in relation to the proposed bill.
Yes, Your Honor, Mr. Chair, I am Deputy Director General Quinto of PDEA, and I'm representing Director General La Peña, who is now attending budget meeting with Congressman Añete here in Congress, Your Honor. As regards to our statistics, Your Honor, may I inform the body that since the start of the war against drugs, we have so much significant accomplishments. And this includes the apprehensions of drug personalities belonging to the who are public officials. From 2011 to July 24, 2017, we have so far apprehended 300 drug personalities, and these are also provincial board members, municipal councilors, vice mayor, barangay kagawats, barangay chairman, and also some candidates for mayors. What I'm saying, Your Honor, is that drugs, the proliferation of drugs affected already everybody. And that includes law enforcement, members of the law enforcement agencies and public officials. So,
DDG, if the chair may cut you, can you give us, I just missed that data of the figure. You mentioned the figure earlier of local officials. There
300
are
300 local officials, Your Honor.
so 300. If we dissect that,
363, Your Honor.
363 identified. So if we dissect that, this includes barangay captains,
Yes, Your Honor.
councilors, mayors,
Mayors, vice mayors.
board members, vice mayor.
Yes, Your Honor. And I think it's time that with intensified campaign against illegal drugs, as declared by, ordered by our president, it's time that we pass this, we amend Republic Act 9165, Section 36G of Republic Act 9165, so that all aspiring for the public office, Your Honor, must be tested negative with drugs.
Thank you. Yes, Congressman Costello.
Thank you very much,
Bit-
Mr. Chairman.
Can I just
No problem.
recognize our
No objection.
member
Of course.
who just arrived,
We should
Congressman Lawrence Fortun, who just celebrated his birthday
Happy birthday, sir.
recently. So please proceed, Congressman Costello.
Thank you very much, Mr. Chairman, and allow me to congratulate you, Mr. Chairman, for calendaring this very important piece of legislation. But may I just divert, no point of information, inquiry, if when we will be discussing a very important proposal that would extend the holding of the elections, Mr. Chairman, if you may.
That will be scheduled on August 14, Monday. Are
Thank you
your
very
barangay
much.
captains
Can I
clamoring
just-
already to
Yes,
have
because
that
they are trying
vital
to solicit.
information?
They are trying to
Congressman?
solicit from me. Then I will just tell them that to go to your office for the solicitation. But yeah,
Thank you.
In
So that
fact-
will be on Monday.
okay. I will. May I just register from the COMSEC that I will be asking the first question? Okay. Thank you.
Very
very much.
advanced, ano po?
Naman naman tayo
Anyway.
advance sa QC.
Thank
Sir.
you.
Sir, have we invited, this is, I would like to congratulate the author, but have we invited different national federation of offices, of elected positions like the ABC, like the Vice Mayor Association of the Philippines, the Mayor Association of the Philippines, the Councilors League, the Board Members League, because I think this will greatly affect them, and we should also hear their side and their position on this matter. Has the COMSEC or
Yeah.
invited the same?
Yes,
Mr. Chairman?
for the information of everyone from the chairman, as always and in all our committee hearings, we invited them. But I think there might be a possibility that I might be opening our rules and open the chapter about contempt, because despite several requests for them to attend, for them to participate, they are not attending. So we might revisit that. Anyway, let's now proceed with the COMELEC regarding their position on the proposed mandatory drug testing. On those officials, I will dissect it. The chair would like to dissect it. On the proposed mandatory drug testing, of those who are stated, of those positions stated in the Constitution, and the others which are stated in the local government code and the Omnibus Election Code. Attorney Rodriguez.
Good afternoon, Mr. Chair, Your Honors. Sir, I'd like to I commend the honorable author of House Bill number 5680 for coming up with this novel bill in order to curb the current drug problem. However, ma'am, I echo the sentiment of Congressman Urbareta and the representatives from the PIDEA that there was indeed a case decided by the Supreme Court. If I may, it's the Social Justice Society versus Dangerous Drugs Board et al. GR number is 157870, decided last November 3, 2008. Actually, Your Honors, this is a consolidated case because this case was filed, the constitutionality of RA 9165 was questioned before the Supreme Court because if may I be allowed, Your Honor, Section 36G of said law states that, and I quote, all candidates for public office, whether appointed or elected, both in the national or local governments, shall undergo a mandatory drug test. Pursuant to this provision of the law, Your Honors, for purposes of the 2004 elections, the COMELEC promulgated COMELEC Resolution 6486, requiring all candidates to follow this mandate of the law. Senator Pimentel filed a case. It was among included in this consolidated case, Your Honor, questioning said resolution of the COMELEC. And the court said that the qualifications for senators are provided for by the Constitution. And by analogy, Your Honor, taking from this particular decision of the court, it follows that the other candidates whose qualifications are provided for by the Constitution, namely the President, the Vice President, senators, and members of the House of Representatives are all provided by the Constitution. So therefore, Your Honors, said qualifications cannot be modified by legislation. However, Your Honor, going to the question of the chair, what about the other elected position? Governor, vice governor, down to the barangay excuse me, officials, Your Honors. Section 65 of the Omnibus Election Code states that qualifications for elective local officials, the qualifications for elective provincial, city, municipal, and barangay officials shall be those provided for in the local government code. The local government code, Your Honor, particularly Section 39, stated the different qualifications, namely residency, the age. So, Your Honors, we submit that the qualifications pertaining to those mentioned in the Constitution cannot be modified by legislation. However, Your Honor, if it is the intent of this honorable committee, particularly of the author, to amend qualifications provided for those mentioned in the local government code and in the Omnibus Election Code pertaining to local government officials, Your Honor, then we do not interpose any objection thereto.
Thank you. How about from... Okay. Yes, Congressman Castello.
Clarification on the manifestation of the Council of COMELEC. Well, your chairman is in the papers right now. I suppose he will also attend in our August 19 meeting. He was invited. He confirmed. Everybody will be anticipating for his presence. However, Mr. Counsel, with your manifestation, what is covered only are the position of what was written in the Constitution, right?
Yes, Your Honor. What is covered in the decision of the Supreme Court are those provided for by the Constitution.
So as far as those positions are concerned, outside of that, I mean, outside of those that you have mentioned, okay kayo doon. You do not interpose any objection.
Well, Your Honor, it is within the wisdom of this honorable body, Your Honor, to amend local laws or legislation, so we do not have any opposition
So
there.
if
to Your
ever
Honor.
the Roman bill will become into a law, no, it would supplant and supersede all the provisions under the qualifications, no, and in the Omnibus Election Code and the Local Government Code. Tama ho yun?
Yes, Your Honor, only for local elective positions, Your Honor.
Thank you very much, Mr. Chairman, for the clarification.
Yes, thank you, Congressman Castello. We recognize Congressman Fortun.
I just have one query. Will that not be some kind of a class legislation if we put a drug test as a qualification for local government officials or candidates, and we do not have that requirement for senators, congressmen, the president, and the vice president? What makes the local government officials different, no, from the national officials like the president, vice president, senators, and members of the House?
Well, Your Honor, just like to clarify that this is just my personal opinion, Your Honor, in order to address the concern of Congressman Fortun. This is just my personal opinion on that particular issue. Your Honor, I don't believe it will be considered as a class legislation because Section 65 of the Omnibus Election Code states that those qualifications for those local elective officials shall be provided for in the local government code. And it is a legislation, Your Honor, if it is the intent of the Congress, both houses, to amend the law in order to address current situation, Your Honor, then I think it is within the power of this honorable body to modify qualifications provided for by law.
Mr. Chair, short comment. I'd just like to
Yes, you are recognized, Congressman Uy Barreta.
Yes, just like to extend my belated birthday greeting to our colleague. Happy birthday po. Blow out niya po lahat ng merienda natin ngayon.
Thank you. Well, I just do not want to lose this thought, but in relation to the question of Congressman Fortun that it might result to class legislation, I think the remedy to address the issue of those that are stated in the Constitution is to amend the Constitution. Anyway, that is the subject of a different matter, but that is from the point of view of the chair. May we ask from Mr. Ramon Casiple, what can you say on this particular electoral reform? Because this will surely be aligned with the president's war and the administration's war on drugs. Yes, Mr. Casiple.
Well, thank you, Mr. Chair. Of course, the point has already been made that the Supreme Court found it unconstitutional with regards to the national elective officials. I have my reservations, actually, additional reservations on 2 points. One, the question of the use of drugs, and I would like the PDEA to clarify this. Is the use of drug a crime? Because it's clear in the Omnibus Election Code that criminals of a certain level of penalty are actually banned from running. But the idea there is that you're a criminal. So the question here, if let's say there is a drug testing and you're found out to have ingested marijuana, will that make you disqualified running for office? Meaning, is there no specific type of drugs that you have to be found out and then you become a criminal? That is a test, I think, that should be applied here. Because I think, from what I understand from the author, the idea is you should not have somebody who may commit a crime or is actually committed already a crime from being elected into office. That's the first one. I mean, you really have a question. The second point is from a human rights angle. The UN, as in the Universal Declaration of Human Rights, has already made clear many grounds that may constitute discrimination. And I think this type of discrimination falls into it. In the sense, I don't know if it's class discrimination, but many countries have different ideas with regarding drugs and drug enforcement. Of course, we are a country, we have sovereignty, we have our own ideas. But as I've said, I don't know if simple drug use of a specific substance is a crime, and therefore can be used to disqualify a candidate or an appointed official for that matter. So I think there is still a great deal of discussion that should be done with regards to this particular issue, Mr. Chair.
Thank you, Mr. Casiple.
Mis-
Before,
Mr. Chair.
excuse me, Congressman Uybarreta, before I ask DDG Quinto on the first question of Mr. Casiple, I would like to recognize the distinguished Deputy Speaker Fredinil Castro, the former chairman of the Committee on Suffrage and Electoral Reforms. Good afternoon, Deputy Speaker. So, Congressman Uybarreta, please, you were saying.
Just a short comment on what Mr. Casipe has mentioned. Yung crime, there are certain crimes that yung penalty also includes perpetual disqualification from running office. But on those occasions, it needs to have a final conviction for that particular crime. So our distinguished resource person here has raised a very valid and interesting question. Does it mean that if one is found during a random test to be a user, does it constitute already a final conviction as far as him being disqualified or perpetually disqualified to seek public office?
Thank you, Congressman Uybarreta. I think your question is a restatement of question number 1 of Mr. Casiple. Well, we have not. This is merely the first hearing of this particular bill. We will have more hearings on this because this is a relevant matter with the current state of our nation. And assuming that this bill has turned into a law and PIDEA has become the clearing agency before a local government official can run in an elective position, how do you think we will operationalize this in relation to the question of Mr. Ramon Casiple and Congressman Uybarreta?
May I refer the matter to our legal, Your Honor?
Yes, DDG. Attorney Del Valle, Pañero, please.
Good afternoon once again, Your Honors. In response to the question of Mr. Ramon Casiple or Sir Casiple, I would like to inform this body that there are a lot of dangerous drugs stated in RA 9165. So it's not only the common dangerous drugs that we know. Now, those who will use any of those dangerous drugs listed in this RA 9165, regardless of the quantity or quality, if that person will be found positive for drug use after the screening and confirmatory test, that is a violation of Section 15 of RA 9165. And in RA 9165, it was stated here that those who will be found positive for drug use, first offense is for referral sa government rehab. Second offense, the penalty is the 6 months and 1 day to 6 years imprisonment. So that was what is stated in RA 9165, Section 15.
Thank you, Attorney. What we are contemplating is, again, I will go back to the premise na kunyari, naaprubahan na itong batas na to, na may counterpart bill sa Senado na nagpareha sa atin, nag-bycam tayo, pinirma ng Presidente, and in the law, it will now be PIDEA as the clearing agency. Ano kaya ang magandang gawin nating procedural o procedure? Halimbawa, maghahalala na 2019 at pupunta ako sa COMELEC, magfa-file ako bilang isang kandidato sa isang LGU position. At ano kaya ang requirement? I mean, may requirement na, pero paano ba yan? Kung halimbawa, let's use the example of Juan de la Cruz. I will not use myself. Let's use Juan de la Cruz. He went to PIDEA to secure a clearance as a requirement for filing COC. And then, halimbawa, for unknown reasons, biglang-bigla, alam mo naman, hindi ka naman gumagamit ng drugs, tapos bigla kang nag-positive. Syempre, political right ang nakasalalay dyan, di ba? Na hindi ka na gusto mo maglingkod, alam mo may kakayahan ka, and yet hindi ka na makapaglingkod dahil outright, dun sa random testing, nag-positive ka. So, paano kaya ang naiisip mong procedure? Kasi, here in the lower house, before we go in approving this particular measure, if it will be, we need to know the prospective IRR of this particular bill already. So, can you have, at least a synopsis or a snapshot to address the war on drugs, mandatory drug testing, but at the same time, giving an opportunity and due process also, and that includes the right of appeal on the part of the aspirant.
Mr. Chair.
Yes, Congresswoman.
Yes, actually, I was already imagining the situation if supposing that this bill actually passes into law. The scenario would be, he's not a drug user, but he tests positive in PDEA. There should be a right to appeal, and also they should be carried out through an independent drug testing laboratory that is also recognized by, let's say, by the government. Not necessarily the government agency, but an independent laboratory, for example, that disposes of the necessary licenses, etc., etc.
Tapos I will also include there nationwide ang halalan, DDG. So ang PIDEA ho ba may kakayahan on a nationwide scale na maging clearinghouse ng mga kakandidato sa local elections? Ito, mga ano po to? Yung organizational structure natin. Kasi titignan natin yung capacity ng agency to be the clearing agency. Kasi wala, I don't know, maybe, I have to check, no? Pero hindi ko nakikita ang DALG to be the clearing house kasi wala naman silang expertise on this particular matter. Yes, DDG Quinto.
Your Honor, hanggang region lang po ang laboratory namin existing right now. Yes, our forensic capability is up to the region lang. Nasa region lang po, Your Honor.
So hanggang region lang po, DDG?
Yes, Mr. Chair.
Okay. Before I proceed to my next question, we would like to recognize the Vice Chairperson of the Committee on Suffrage and Electoral Reforms, Congresswoman Luisa Lloren Cuaresma. Good afternoon. And then we would also like to recognize the gentleman from Cagayan de Oro, Congressman Maximo Rodriguez. Good afternoon. So, DDG, Attorney Del Valle, paano ho kaya yon?
Ma'am, I would like, sir, Your Honors, I would like to add the answer of the DDGO, which says that
Region lang.
sa ngayon po, we have only forensic laboratory sa mga regional offices ng PIDEA. In all the regions dito sa Pilipinas, we have one forensic laboratory. And per region, we only have 2 to 3 chemists. Now, if we only have 2 to 3 chemists per region, it would be difficult on our part to cater of all those candidates for elective position. However, as a suggestion, maybe we can accredit those who are in the DOHs for them to help us to give service to those who want to undergo the mandatory drug testing, sir.
Thank you.
Or deputy.
May I seek the opinion of the former chair on this particular matter about delegating or deputizing a very sensitive matter because it might deprive a Filipino of running for public office because there was a wrong testing conducted by a deputized public or private entity.
To my opinion, in order to address the situation, perhaps government hospitals could be deputized to conduct the testing all throughout the country. And with that, we are sure that those who will submit themselves to test would properly be attended to with the expert handling them. Because we also have our own laboratories in different government hospitals.
Thank you, Deputy Speaker. How about from NAMFREL, Mr. Alvia? What is your position on the bill on hand?
Yeah. Good afternoon, Mr. Chairman. Good afternoon, members of the committee. Thank you very much for introducing this novel legislation. We realize also the limitations, the unconstitutionality of introducing that idea. But yet we see that it's a necessary move given the circumstance and situation that we have right now. I guess what COMELEC has mentioned earlier regarding Section 39 of the Local Government Code should be revisited. It's an opportunity for us to introduce such legislation given the limits imposed by the Constitution. On the other hand, it could also be used not necessarily as a requirement, but even as an option by COMELEC to just allow candidates to just go through a drug testing, and it's up to them, it's up to the COMELEC to divulge to the public if they submitted themselves to drug testing or the results. So at least the public may know. It's a service that you can provide to the voters, at least of the real status of their candidate. But again, the premise now bears on the fact that it doesn't necessarily mean that if you're a drug user, you're already involved in illegal drug-related activities. So it boils down again to the courts deciding. So it's a tricky introduction of a novel legislation, but yet we see it and view it as necessary. And until such time that you amend the certain provisions in the Constitution, then I stick to what is doable, which is again looking and revisiting the Local Government Code. Thank you, sir.
Thank you, Mr. Alvia. Before we also ask the opinion of our other stakeholders, we would like to recognize Deputy Speaker Sharon Garin. Thank you, Deputy Speaker. So, well, all that were discussed, that have been discussed, are part now of our records, and in the continuing deliberation of House Bill number 5680, we will be seeking more inputs, in particular the prospective IRR, because I, as the chairman, I do not want a bill that will pass through our committee that has fully delegated or has not even tackled the procedure that will be done in case the bill turns into a law. So may I seek also the opinion of my colleagues here in the Committee on Suffrage and Electoral Reforms on your view about the mandatory drug testing of local government officials. May I recognize our Vice Chairperson, former Governor of Nueva Vizcaya, Congresswoman Quaresma.
Thank you very much, Mr. Chairman. Magandang hapon po sa inyong lahat. I heard our resources speaker here say that it should be the drug testing should be done in a government facility. I mean, government drug testing facility. But I would like to inform everyone that not all, particularly in small provinces, there's a hospital or a not even the PHO, Provincial Health Office, doesn't have like a drug testing equipment. But in my province of Nueva Vizcaya, we have, because we earn from this before. Okay, that's an input, Mr. Chairman.
Thank you, Congresswoman Quaresma. Any other inputs? Congressman Edwin Ong. Yes,
I
please.
think right now, while we're renewing our driver's license, we are required to have a drug test also. So maybe we can just pattern it with the Land Transportation Office. Kung what's the opinion of the DDG if we just pattern it by using drug testing centers?
Mr. Chairman,
Thank you,
if I
Congressman
may,
Ong. Yes, in relation to
perhaps
yes, Deputy
all
Speaker.
those we can make it obligatory on the part of the Department of Health to provide each and every government hospital under its jurisdiction to acquire testing equipment for that. Because, you know, this will be helpful not only insofar as this bill is concerned or the implementation of this bill, but more importantly, from time to time, people are apprehended because of violation of drugs. And therefore, even in the prosecution of all those who were apprehended to prove their innocence or their guilt, laboratories, drug laboratories, for purposes of testing, the arrested person or the suspect will always be needed. No? Therefore, why can't we not provide a provision requiring the Department of Health as obligatory on its part to acquire testing equipment? And perhaps, again, the government, we can also include an appropriation in the bill by perhaps in the second hearing or second meeting, we can ask the Department of Health to be represented in this committee so that we will know the extent of the network of network of the Department of Health. More than that, perhaps we can also make it obligatory on the part of local government units, referring to provincial government, to acquire for the same reasons that for the implementation of this proposed law, including prosecution to prove the innocence or the guilt of any person who may have been arrested because of drug violation, could also be useful insofar as prosecution is concerned.
Thank you very much, Deputy Speaker. That is why it's very important to ask the opinion of those who has the wisdom.
Mr. Chair.
So our author should take you. There's a current Appropriations Committee hearing. I believe the Department of Health, Health's budget will be tackled also. So this is, it will serve us well if we look at the current state of the government hospitals in the provinces. Yes.
May I add further,
Yes,
Mr. Chairman,
Deputy Speaker.
please? I was listening to the suggestion of Congressman Ong that when we renew our license, there are some outfits, Stop and Shop, for example, doing the testing. That is very expeditious and convenient, but that's very dangerous because these outlets, no, for drug testing, for purposes of renewing our driver's license are not reliable. In fact, they could be bought to come out with negative result during the test. And there is no better alternative except government hospitals. That's the best, at least for the moment.
Thank you, Deputy Speaker.
Mr. Chair.
Congresswoman Roman.
Yes. Representative Fortune was sharing to me that in 2007, they actually complied with this requirement before the requirement was deemed unconstitutional by the Supreme Court. And as a counselor then, they were required to submit a drug clearance, which he obtained from
any drug testing. From any drug testing center accredited by the DOH.
So that is a proof that this is something feasible. And I was also thinking maybe during the period of the filing of candidacies, the COMELEC office or the Department of Health could actually field a mobile testing unit in all COMELEC centers where the filing of COCs is done to produce immediate results. I am now unaware of the nature of the test. Is it something immediate, like a pregnancy test, or is it something like that?
Yes, Deputy Director General or Attorney Del Valle.
Good afternoon once again. I consulted our chemist from the laboratory service of PIDEA. Now, as to the result of the screening test, if the result is negative, you can get the result within 15 minutes from the time that the sample was taken from that person. However, for those who will be found positive for the screening test, this person should undergo the confirmatory test. And based on the manual from the DOH, that will be given within 3 to 5 working days. Now, as in addition, Mr. Chair, as regards the procedure that is being asked a while ago, maybe we can consult the chemist from the DOH so that they can give us the proper procedure, because those persons are catering services to different persons who are required to undergo mandatory drug tests. So their opinion might be of help to us.
Okay, thank you, Attorney. I think the matter has been substantially deliberated, but we still have more details to work on. We need more inputs from the experts and also from our members of the Committee on Suffrage. So for now, we will be moving from item A. Do I hear any motion?
Mr. Chair,
yeah.
just before we
Yes.
go to the next item on the agenda, I just want to more or less summarize as the author, I'm concerned about the two things: the legal feasibility of this measure, and number two, the operational and practical feasibility. And I would say, Mr. Chair and distinguished members of this committee, that I would like to summarize what your recommendation is, that removing the requirements or the proposed measure when it comes to the national positions such as President, Vice President, Senator, Member of the House of Representatives would make it feasible if applied only to the local government units. And from the operational point of view, more or less we have seen that well, it is possible. It was done way back in 2007. It can be done nowadays with the development of new technology. So I don't know. So I submit my bill again to the study and analysis of our committee, Mr. Chair, after hearing all of their observations and recommendations.
Mr. Chairman,
Yes, Deputy
before
Speaker.
we end deliberating on this measure, considering that in the discussion many issues will have to be addressed, may I move, Mr. Chairman, that we create a technical working group to go over this matter, to be represented by representative from the Department of Health. One. Second, perhaps there should also be a representative from the Commission on Election. Third, there would be representative coming from the judiciary for purposes of, I overheard you saying that this is a matter of right, because any person who is caught or caught with drugs and tested positively will be disqualified. No? Therefore, we've got to improvise in our implementing rules a summary procedure on how he could appeal and how this matter could be could be resolved with finality before or after the filing of the certificate of candidacy, so as to safeguard the right of person to be a candidate, no, per constitutional right. Perhaps a technical working group will do. 2 or 3 meetings will be enough to come out with a more refined draft of the proposed measure.
Thank you, Deputy Speaker. Actually, that was also the suggestion of Congressman Uy Barreta. Let's take note of what the Deputy Speaker suggested. So, any second to the motion of the Deputy Speaker?
Second.
The motion is approved. The Roman bill is, we will now be forming a technical working group, and there will be another meeting to further discuss with the attendance of those that were mentioned by Deputy Speaker Castro. Let us now proceed with item letter B on the topic of the initial deliberation on stiffer penalties on election-related offenses, House Bill number 520, sponsored by Deputy Speaker Fredinil H. Castro. May we hear from Deputy Speaker Castro, please?
For brevity, Mr. Speaker, Mr. Chairman, may adopt the explanatory note as my sponsorship speech. And this representation hastens to add that there is also a similar bill which was filed by Congressman Maximo Rodriguez. And therefore, without trying to preempt the good gentleman from Cagayan de Oro, I would suggest that both bills be consolidated, because if you are going to read superficially the proposed measure, it only identifies person who should be criminally liable for violating certain provisions of the Omnibus Election Code, and also increasing the penalty, because to our minds, I think Congressman Rodriguez also shares the view of this representation that the penalty provided as originally provided by law is no longer applicable in practical at this point in time. They could even be they are negligible, that would not even deter anyone from desisting from the commission of crime violating this particular law, Mr. Chairman.
Yes, Deputy Speaker Castro. In that case, will you put that in the form of a motion so that we will be consolidating the two related bills?
Congressman Rodriguez has not given yet, or has not delivered yet, his sponsorship speech. Perhaps he should be allowed first to sponsor his measure, and then after which the chairman may propose the consolidation of both measures.
Before we recognize our sponsor, I am now turning over the chairmanship to our chairwoman, Congresswoman Quaresma. Thank you. I-recognize lang si Congressman Rodriguez para sa speech.
Okay, so good afternoon once again. Tapos na ba yung kay ano? Nandito ngayon susunod si Congressman. So are we done with the... Are we done, Deputy Speaker? Fredinil Castro, with your proposed House Bill? Okay, so we're done. So maybe we can now move on to the next agenda, which is House Bill number 1692 by Representative Maximo B. Rodriguez Jr. So may I now recognize Representative Rodriguez.
Thank you, Chairperson. Good afternoon, everybody. Having heard from my idol, the erudite Congressman Castro, who have aptly said the right words to it, that there should be consolidation, I really don't have any objection on it. So, by habit, I would say I would really have no objection to it. Okay, having heard from his statement, only that I would like to emphasize that this bill has been filed in the two last Congresses. And the last Congress, it was filed also. It was submitted to the Senate, where it was not approved. It was not taken and approved. And so I would submit to the chairman that this explanatory note be considered as my sponsorship remarks. And I will be able to help in any way in the crafting of this bill with the committee in the event of a technical working group be created to harmonize provisions and to come up with a so we say a stronger bill to prevent election offenses in this country. Thank you, Chairperson.
Okay, so thank you, Honorable Rodriguez. Now, before we proceed to, before the chair will recognize our sources speaker, may I recognize the presence of the Honorable Crystal Bagatsing of the 5th District of Manila, a member of this committee. So may the chair now recognize our resource person, Attorney Albert Rodriguez from the Law Department of the Commission on Election.
Good afternoon once again, Madam Chair, Your Honors. These two bills, House Bill numbers 520 and 1692, excuse me, authored by Representatives Castro and Rodriguez respectively, were among those deliberated by the Commission en banc this morning. Your Honors, the Commission recognizes the intent of the authors to increase the penalty of election offenses, Your Honors. But however, upon deliberation, it is the Commission's humble opinion that the current penalties, which are imprisonment of 1 year to 6 years under the current under the Omnibus Election Code, be maintained for several reasons, Your Honor. Notably of which is when the Commission tried to discuss election offenses covered by not only by the Omnibus Election Code but also by other election laws, there are if ever that these bills will be enacted into law, Your Honors, then there might be a situation which can be considered absurd. This situation, Your Honor, is, for example, a person found to have violated Section 261, Paragraph DD of the Omnibus Election Code, which substantially states that it shall be prohibited for any person to take, to buy, to sell liquor or alcohol during election day or a day before election, Your Honor. So there is a situation now that an innocent person, it so happened that that person was intoxicated, so therefore he violated an election law, and the penalty will be imprisonment of 6 years. That person, Your Honor, is just intoxicated. No intention upon to commit any election-related acts or violence, whatever the case may be, Your Honor. Just plain intoxication. So there is now this situation, Your Honor, that a person will be imprisoned for 6 or even 12 years. So that is one absurd situation, Your Honor, that might result if this law will be, if these bills will be enacted into law.
Mr. Chairman,
Yes, Honorable Deputy Speakers, recognize.
I really did not want to respond to the statement of the gentleman from the Commission on Election, but this representation was provoked to respond to that because it's not really observed. Whenever he is innocent or guilty, will always be delegated to the sound discretion of the court. And therefore, I am not going to overstep on the authority of the judiciary. I am not going to intrude upon the prerogative of our courts. And therefore, whether the one intoxicated or not is really guilty or not will depend on the decision of our courts. Madam Chairman.
Okay, maybe the representative coming from COMELEC already, had noted of that comment of our the author. Now we still have one resource speaker in the person of Attorney Renel Tatlonghari. Yeah, you're recognized, gentlemen.
Good afternoon, Your Honors. We understand that the provision on the penalty of election offenses may be antiquated, but the Commission on Elections and Bank had already ruled on the matter, and we submit to their opinion that we rather maintain the section as is. Your Honor, for the information of the body, the top 10 violations of election laws committed and as recorded by the Law Department are as follows. Number 1 is overspending, or the violation of Section 100 in relation to Section 262 of the Omnibus Election Code as amended by 7166. Number 2 is material misrepresentation on the content in the filing of COC. Number 3 is vote buying and vote selling, Section 261A of the Omnibus Election Code. Number 4 is threats, intimidation, terrorism. 5, intervention of public officers and employees. 6, the election offense committed by Board of Election Inspectors, members of the board, who has made possible the casting of more votes than there are registered voters. 7th, premature campaign. 8, use of public funds or money deposited in trust and equipment owned by the government. 9, violations of Fair Elections Act. And 10, violation committed by members of the BEI for engaging in partisan political activity during election day.
Yes, Honorable Fortune is recognized.
Thank you, Madam Chair. Question lang sa COMELEC. Would you not rather recommend that we impose higher penalties for those offenses that you have just enumerated in order to avoid a situation that you may call absurd? Baka pwede namang dun sa mga matataas na violations, dun natin ilagay yung mataas na penalty. Then we can probably stick with the current penalties with the other supposedly lower offenses.
Okay, yes.
Madam Chair. Sir, for the information of this body, the COMELEC pursuant to its COMSTRAT 2017 to 2022, that's the strategic plan for the COMELEC. We are currently reviewing the Omnibus Election Code and other election laws for possible codification, Your Honors. Pag natapos po ito, sasubmit po namin to both houses for enactment dahil ang plano po namin, there should only be one Omnibus Election Code para hindi na po tayo mahirapang mag-refer sa iba't ibang batas. Yung pong sinabi po ninyo, sir, is isa po sa mga ginagawa po namin ngayon, which is ina-identify po namin yung mga batas according to gravity, yung mga violations rather according to gravity. Kasama po rito sa bills po ni na Congressman Castro and Congressman Rodriguez that if the act is accompanied by threat, intimidation, coercion, that it is an automatic aggravating circumstance. Maximum na po kagad if I am not mistaken. So, isa po yun sa tinitingnan namin. Ina-analyze po ng mga kasama po naming mga lawyers doon and other staff po ng offices kung ano po ba yung mga election offenses according to their gravity. Tama po yung sinabi nyo, Your Honor. dapat po siguro itignan natin ano ba ang batas na dapat mabigat ang parusa, anong batas na, na magaan ang parusa. Tama rin po si Congressman Castro kanina na nasa discretion po iyan ng judiciary. But if ever po nagagawa po tayo ng batas, maganda po siguro parang revised penal code, meron tayong scale. Ano bang grave offense, ano bang less grave offense, so on and so forth. Ginagawa po namin yan ngayon. In connection po dito sa binasa po ni Attorney Tatlongari, sinabi po niya dito is that overspending po yung pinakamarami. As of now po, we have 1,870 cases filed for overspending. Medyo iba-iba po yung datos. Meron pong umaabot ng 500,000. Meron pong nag-file ng 1 billion. Di ko po alam kung tama po ba. Talagang gumasto siya ng 1 billion. At meron din naman pong sumobra lang ng piso. So since ito po ay mala prohibita, hindi po natin titignan kung may intent o wala yung nag-violate. So assuming po itong kandidato na gumastos po siya, sumobra lang siya ng piso, 2 piso, ang penalty po according dito sa ating mga panukalang batas is 6 years to 12 years. Mukhang mabigat po yata iyon. So yun po yung naging isa sa mga basehan po ng komisyon kanina nung inaaral po nila yung mga panukalang batas na parang siguro hindi ganito outright na 6 to 12 years or even 12 years to 20 years. Kasi meron din pong provision dito na 12 years to 20 years. Mukhang may mga violations po na hindi commensurate yung ibinibigay nating parusa. Yun po yung opinion po ng komisyon po kanina.
Madam Chair.
Yes, Honorable Castro.
Anyway, there is no use arguing with the representatives of the Commission on Election because it's still the wisdom of the members of the committee that will prevail and could not be supplanted by any recommendatory opinion of the Commission on Election. But let me comment on the overspending. I think in overspending, the solution there is not really a new law that would penalize lesser or increase the penalty. But I think the solution there is to increase the ceiling of the amount that could be spent by any candidate, because the present law that pegs to its lowest level the expenses that may be allowed any candidate is no longer practical and applicable. Therefore, I think we should revisit again. No, I filed a bill increasing the allowable expense on the part of the candidate in the 16th Congress, but this was not given any consideration. No?
So, in other words, this is different from what you filed during the previous
yes,
Congress.
yes,
Your
Madam
Honor.
Chairman. That's why going back to my previous position, while COMELEC has taken its position and has given us our recommendation, yet the wisdom of the members of the committee could not be supplanted by that recommendatory opinion of the Commission on Election.
Okay, well taken. And we just take note of your observation or recommendation or whatever. But I would just like to ask as to whether vote buying is a part of those. Okay. So maybe also here from from the NGOs, we have Mr. Ramon Casiple, the chairman, Consortium on Electoral Reform. Sir, you're recognized, please.
Thank you, Mr. Chair. Actually, I support both the COMELEC here and Congressman. I support also the bill, actually. Our own observation during the past election is that, one, many of the offenses actually are hard to prosecute. Second, the level of penalty is too low for some. So we would support in general, in principle, the increased penalties for election offense. On the other hand, I also support the question of gradation of penalties, meaning those that the COMELEC considers as absurd. Then we have only a level, let's say 1 year or whatever, not a uniform penalty for all the offenses. So I would support the opinion from the COMELEC that there should be a stages or levels of penalties. But I would support principally the question, the proposal for a increase in the penalties.
Okay, so thank you, Mr. Lito Aberia. Okay, we have to move faster. It's 3:20. Okay, yes, gentlemen, honorable
Just one
court, please
query pa sa
recognize.
COMELEC. Tanong ko lang I want an honest answer. Number one, is the penalty, the degree of penalty really the problem here? I'm just concerned because if we might be passing laws that would increase penalties, no, for offenses, no, involving election laws, but just the same offenses will proliferate because we are unable to enforce these laws. Now, for example, in the case of overspending, we know for a fact, siguro kahit off the record, we know for a fact that almost everybody has overspent in the last elections, and yet you only have 1,000 overspending cases, no, filed formally. For instance, in the case of vote buying, you also know for a fact that vote buying is prevalent everywhere in the country, and yet we only have a very low number of cases involving vote buying. So is this really a question of stiffer penalties, or this is a problem of enforcement actually?
Attorney Tatlong Hari.
Your Honor, we need the support from the public. As we all know, and for the information of the body, an election offense may be initiated motu proprio by the commission or by private complainant by filing a verified complaint. In the case of motu proprio complaints filed by the law department, Your Honor, we cannot initiate a complaint for vote buying, for instance, because we do not have personal knowledge as to how the election offense of vote buying was committed, for example, in Barangay A. So we need the affidavits of witnesses, evidence, documentary, etc., documentary evidence or whatever to support such complaint. So a complainant is necessary. In the case of a private complainant, we need a verified complaint. It is stated in our 1993 COMELEC Rules of Procedure that we cannot act on every complaint because a verified one is needed. Ito po yung ginagawan din ng paraan ng komisyon kasi, for example, marami pong anonymous complaints na rin. So, in the strategic planning of COMELEC, kino-consider na rin po na like other agencies, Ombudsman, Commission on Human Rights, na nag-consider ng anonymous complaint na kung pwedeng kami ay tumanggap na rin ng ganong. So, in short, sir, kailangan po namin ng cooperation and vigilant citizenry.
Thank you, Attorney Tatlong Hari. Does that are your queries, Congressman Fortun, answered already by? Anyway, our representatives and the heads of PIDEA, they are going to attend to their budget hearing, so they are excused. Thank you very much, Deputy Director General Quinto, Attorney Del Valle. Thank you. And on the particular bills of Deputy Speaker Castro and Congressman Rodriguez, may we hear from Mr. Alvia and Mr. Aviria?
Yeah. While we agree with our colleagues here also, and we realize also that there may be some disproportionate application of penalties, so we submit to the wisdom of the committee, and probably also the suggestion of our colleagues that probably should be proportionate and graduated, no, according to the offense. No, we also would want to see in the bill, hopefully, certain provisions that would possibly protect also election workers from being victims of nuisance complaints, because this could be possibly abused by certain parties or individuals to impinge or even to prevent them from conducting their election duties. So we don't have any major concerns, except that, no, that it may be misused. No? So it would be good if there are provisions there that if found out that there are people who would misuse this bill, no, to prevent them or to coerce them or to threaten them from doing their duties, then corresponding penalties should also be applied to them. Thank you.
Thank you, Mr. Alvia. How about Mr. Aviria? Any input before we end our current meeting, as we have a 4 p.m. session in the plenary, and if we are not there, we cannot enter anymore. We will be absent. The plenary is being locked.
Good afternoon, Mr. Chair. We've been, well, my colleague Eric and I were having sidebar discussions here, no, on what to say, and he has expressed actually the sentiments of NAMFREL. No? Yeah, I guess for the two bills, actually, it's really, the problem is really enforcement. You know, how do you track down, for example, who the violators are and how to file complaints? We realize that it's very difficult. So that's going to be the challenge for COMELEC, really. But we interpose no objections to the increase of penalties because the penalties provided for in BP 881 as well as other laws may be antiquated. They may not be proportionate to the offenses. So a detailed study of those offenses and the corresponding penalties is really needed. Thank you.
May we hear from our distinguished author?
Well, insofar as the two bills are concerned, Mr. Chairman, perhaps we can set it for another discussion for the second time so that it could be further discussed and we could smoothen certain rough edges.
Deputy Speaker, before we hear any motion to adjourn the hearing, we would like to thank our distinguished guests and resource persons coming from the COMELEC, from NAMFREL, Consortium on Electoral Reforms, headed by Mr. Ramon Casiple, and my distinguished and beautiful colleagues, especially here on the left. They're not minding me, very busy with looking at their social media, and to our staff here in Committee on Suffrage, especially our TSN, because I am looking at you, and I will get the TSN by tomorrow or maybe on Thursday in preparation for the next hearing. I will read it word for word. So, do I hear the favorite motion?
Yes. Move to adjourn.
Any second? Second. So, the hearing for today is adjourned. Thank you very much.